Hi, YouTubers. Chris McCraw, imercury here. I'm just making a little video here on Obama going after the cannabis dispensaries in California. And I think this is perfect because it's exactly what he said he wouldn't do. Everything that Obama says he's not going to do, he does. Everything he says, he's a double crossing politician. He's out here promising his Democratic base in 2008 here in California that he was not going to be going after medical marijuana users, and if he goes after the collectives, how else are the sick people going to get medicine? They're not. So, I'm not sure how. I mean, if the corporates even had a solution that was as good as the gift given to us by God, maybe there would be something to talk about. But the corporates don't produce anything that is as good as God. So how can the government interfere with our religious practice by, one, turning a right into a privilege and then trying to issue licenses on that privilege to restrict our access to good medicine? I mean, I got really upset about this years ago when I was a resident of New Mexico. I was a Rastafarian, and I believe that cannabis is holy sacrament. It says so in the Bible, and if you don't believe that, that's fine, but you can't impose your religious dogma on me. And I've got some proof here, so I'd like to share it with you. Albuquerque, New Mexico. Judicial notice, religious cannabis practitioner's license. Christopher McCraw, citizen of the state of New Mexico, hereby certifies by rights secured under provisions of the Constitution of the United States of America, the Constitution of the state of New Mexico, nature and laws of nature, God, that these rights are retained in fee simple, absolute, and held and protected with special regard to rights designated and or set forth as follows. Notice and advisory of rights claimed inviolate. 1. Free exercise of religion is a guaranteed right. Congress shall make no law respecting free exercise thereof, that the right to free exercise of religion is inalienable by United Nations, federal, state, and local statute. Free exercise of religion is the supreme law of the land. Constitutional rights affirmed by the United States Supreme Court are in evidence to this fact. Quote, neither this court nor any branch of this government will consider the merits or fallacies of a religion, nor will the court compare beliefs, dogmas, and practices of a newly organized religion with those of an older, more established religion. Nor will the court praise or condemn a religion, however excellent or fanatical or preposterous it may seem. Were the court to do so, it would impinge upon the guarantees of the First Amendment. That's the Universal Life Church versus U.S. District Court, Eastern District of California, civil number S-1954. Further, the natural right to free exercise of religion entitles the faithful with the impunity to use, possess, cultivate, and distribute cannabis without regard to subordinate laws which have no force of law in this instance. Quote, the door of the Free Exercise Clause stands tightly closed against any governmental regulation of religious beliefs as such, and that government may neither compel affirmation of a repugnant belief nor penalize or discriminate against individuals or groups because they hold religious views abhorrent to the authorities, nor employ the taxing power to inhibit the dissemination of a particular religious view. Sherbert versus Werner, 374 U.S. 398. Further, the Controlled Substances Act of 1970 violates free exercise of religion. Cannabis is a holy sacrament, referred to in the Holy Bible as cannabosum in original Hebrew. Sweet cane, burning bush, herb-bearing seed, tree of life, plant of renown, marijuana, and hemp. All these words describe the same plant, scientifically known as Cannabis sativa. Consumption, cultivation, possession, and distribution of cannabis is mandatory to ensure my individuality, human dignity, and precious connection to nature. Therefore, prohibition of cannabis whatsoever would impinge on First Amendment rights, which are undeniable. Quote, thus we find that the Controlled Substances Act, as applied to Guerrero, substantially infringed upon his right to the right of free exercise of his religion as protected by the United States Constitution and the Organic Act of Guam. Although we conclude that the Religious Freedom Restoration Act may be applicable in Guam, we would hold that even if it were not, in circumstances where a fundamental right is substantially infringed, the government must demonstrate that this infringement is justified by a compelling interest, and that this is the least restrictive means of obtaining that objective. Therefore, we affirm the trial court's dismissal of the instant action. Guam versus Guerrero, 8th of September 2000, Guam 26 CRA 99 TAC 025. Further, the state of New Mexico is forbidden by law from converting a basic right into a privilege and requiring a license or a fee charge for the exercise of that basic right. See Murdoch versus Pennsylvania, 319 U.S. 105. And if New Mexico State does erroneously convert basic rights into privileges and require a license or fee, a citizen may ignore the license or fee with total immunity for such exercise of a basic right. See Shuttlesworth versus Birmingham, Alabama, 373 U.S. 262. Now, if a citizen exercises a basic right and a law of any state is to the contrary of such exercise of that basic right, and said supposed law of any state is a fiction of law and 100% totally unconstitutional, and no courts are bound to uphold it, and no citizen is required to obey such unconstitutional law or license requirement. See Mayberry versus Madison, 5 U.S. 173. Which, and that, by the way, that decision was handed down in 1803, which has never been overturned in 2000, well, it's a lot more now, 211 years. See separate citations. Now further, if a citizen relies in good faith on the advice of counsel and or on the decisions of the United States Supreme Court, that a citizen has a perfect defense to the element of willfulness. And since the burden of proof of such willfulness is on the prosecution to prove beyond a reasonable doubt, said task of burden being totally impossible to specifically perform, there is no cause of action for which relief may be guaranteed by a court of law. See U.S. versus Vitcha, 412 U.S. 346. Obviously, there is no lawful charge against me exercising free religious expression. That is the law. I am immune from any charge that, to the contrary, and any party making such charge should be duly warned of the tort of trespass. You are trespassing on my rights as a citizen. 2. The original and judicial jurisdiction of the United States Supreme Court is in all actions in which a state may be party through subdivisions, political or trust. This includes all state-approved subdivisions and or incorporated cities, townships, municipalities, and villages. LLC, Article 3, Section 2, Paragraph 1 and 2 of the U.S. Constitution. 3. The undersigned has never willingly and knowingly entered into any contract or contractual agreements giving up any constitutional rights which are secured by the Constitution, the supreme law of the land. This citizen is not harmed by any party, has not threatened any party, and that includes and has not threatened or caused any endangerment to the safety or well-being of any party, and would leave any claimant otherwise to their strictest proofs otherwise in a court of law. Conversion of the right of, number 4, conversion of the right of free religious expression into a privilege and or crime is a fraud and is a clear and direct conflict with the United States Constitution, the supreme law of the land. Laws made by any state which clearly in direct conflict or repugnancy are unconstitutional and are notwithstanding in law and are being challenged as such here and thereby are null and void. On their face, no courts are bound to uphold such fictions of law, and no citizen is bound to obey such a fiction of law. Such regulation or law operates as a mere nullity or fiction of law, as if it never existed in law. No citizen is bound to obey such unconstitutional law. The payment, number 5, the payment of a privilege requires a benefit to be received. As the right to free exercise of religion is already secured, it is clearly unlawful to cite any charges without direct damage to the specific party, nor may a citizen be charged with an offense for an exercise of a constitutional right. In this case, the right to free exercise of religion, see Miller versus U.S. 2030 F2D 486. Nor may a citizen